Okay, Carrie,
David,
let
I
you,
don't see the Portuguese channel open. Do you
you-
have it open?
yeah,
Oh, actually, I do see it. I apologize.
it
Thank
should
you.
be, no problem. Carrie, would you like to?
Yes, I would. Okay, well, thank you. Good evening, everyone. Thank you for joining us tonight. We've got an excellent program. The program tonight is on United States immigration. We're having a roundtable to discuss visas, retrogression, and timetables. I'm very happy to introduce Kevin Battle, who is an attorney at law with Miller Johnson firm. His practice focuses on assisting clients in the area of immigration, employment, and related international law matters.
Okay, allow me to translate, Carrie.
Mhm.
Muy buenas noches a todos, bienvenidos. Esta noche estamos haciendo con la colaboración de Miller Johnson, Kevin, de su organización, una mesa redonda sobre todos los tópicos de la actualidad con respecto a visas, retrogresión, tiempos, etcétera. Okay. Miller Johnson es una de las compañías que hacen muchísimo de la migración de profesionales de la salud, particularmente enfermeros, hacia los Estados Unidos.
So welcome, Kevin. Thank you for joining us tonight. And we'll go ahead and get started here.
Okay, so
Thank you for having me.
so Kevin, what we're going to do is I'll similar to like we have the discussion the prior time, we'll be bringing some topics up and we'll discuss them. You as the authority on the subject, please enlighten us on some of these subjects and give us a chance to have a little bit of a back and forth conversation with you.
Sure.
Es lo que vamos a hacer, como esta mesa redonda va a funcionar de manera tal que vamos a discutir varios tópicos, los cuales vamos a ir conversando con Kevin. Él nos va a ir iluminando, aclarando muchas de las situaciones y de esa manera podemos tener una buena noción de lo que está pasando y después vamos a abrir para preguntas. So number one, Kevin, I think for background purposes, let's start by kind of explaining a little bit the employer sponsor process for a visa. I have basically put in here in about 5 steps, so maybe we'll go one by one through each one of those steps. I'll let you explain it in detail, and as you go through each one of them, I'll go and translate for everyone.
Okay, sounds great.
Give me one second, let me translate. Vamos a comenzar explicando brevemente cómo funciona el proceso de obtener su residencia en los Estados Unidos a través de un empleador, el patrocinio a través de ellos. Kevin nos va a explicar por ahí para darles a todo el mundo buen contexto de cómo funciona el proceso. So Kevin, let's talk first about prevailing wages.
Okay. So the first step in the process in getting an employment-based green card is to get a prevailing wage determination from the U.S. Department of Labor. The prevailing wage determination is a document that sets what the minimum wage a individual must be paid in a particular geographical area in a particular occupation. And so a employer, in this case, a hospital, a health system, will submit a prevailing wage to the Department of Labor for a nursing position in their local area. And the Department of Labor would tell them they must pay a certain wage for that job. They can pay above that wage, but that's the minimum amount that they must pay. In order to get that document, it takes about 6 months right now.
And the employer does it as a demonstration to the government that they are not going to underpay any foreign workers
Correct.
that bring into the United States.
It is both to protect the wages for U.S. workers, but to also ensure that U.S. employers are not paying foreign nationals lower wages than they are paying to their U.S. employees as well.
Okay, so let me translate. So, el primer paso en el proceso de patrocinar a un enfermero como un empleador a los Estados Unidos es obtener una cosa que se llama la determinación de los salarios prevalentes. El Departamento de Trabajo de los Estados Unidos y el proceso requiere que el empleador obtenga un documento del Departamento de Trabajo diciendo cuál es el mínimo salario que se le puede pagar en una región, en un área particular del país a una empleado a compañía que el hospital en este caso quiere traer. Esto lo hace por dos cosas, obviamente una para proteger que a nadie va a traer empleados del exterior para tratar de pagarles menos que lo que ganan una, una persona aquí en este país. Este proceso, Kevin nos cuenta, toma normalmente más de 6 meses obtener los permisos del Departamento de Trabajo para que se mantenga el nivel salarial de todos los empleados. So, Kevin, before we move to the next one, my question, I think just to clarify to everyone, this is usually a process that the employer has done way ahead of time before they even start making job offers to employees, because this process will usually take 6 months. And I think the other clarification you may want to offer to people is that usually they try to renew it automatically, so they this doesn't delay for them the possibility of making offers, correct?
That's correct. So, employers will, once they decide that they want to hire foreign nationals, they'll get a prevailing wage determination started usually months before they start to interview candidates. And once they have a valid prevailing wage, it's valid for between 90 days and a year. They issue them at various lengths, but it's usually good between 90 days and a year. And a employer will, before their prevailing wage expires, they'll start to get another prevailing wage in process with the Department of Labor so that they eliminate the gaps of time.
So, yo le comentaba a Kevin que obviamente una vez que los empleadores establecen esto es un proceso que ellos continuamente están renovando para que esto no demore el proceso de que ellos puedan hacer ofertas laborales a nuevos empleados. Normalmente Kevin nos comentaba que esta determinación de salarios normalmente es válida o por 90 días o por un año, así que los empleadores rutinariamente lo están renovando. Okay, so I think, Kevin, I think that's enough of an explanation for that first step. I think we can easily move to the next one. So let's talk a little bit about the famous PERM certification. What does that mean, and how come the nurses don't have to go through that?
Sure. So for non-Schedule A jobs, and a nurse is a Schedule A job, so non-nursing jobs, non-physical therapist jobs, the rest of the type of jobs in the United States, they must go through the PERM process. And the PERM process requires an employer to recruit. So they must test the local labor market by advertising in their local area for the job. They must prove to the Department of Labor that no U.S. citizens, permanent residents, refugees, or asylees that were minimally qualified applied for the job.
And I think this is an important concept, because sometimes we get asked by people in other professions, well, why are you not recruiting I don't know, let's say ultrasound techs, or what are you not bringing laboratory techs? It has to do that this perm determination is required, and employers are either not always ready to do that, or the market not really always shows that there is such a need. Correct?
That's correct. So, as part of the process, an employer has to post with their unemployment agency for the state the job. They have to post in the newspaper of general circulation in the area on 2 Sundays. They have to post a notice to all employees company-wide, and then they have to pick 3 additional steps for recruitment, like advertise on their website, advertise on a third-party website, do a radio ad or a television ad. And so when they're testing um, the market may be in high demand, and so it may not be a good time to recruit. They may post the job and they get 5 qualified U.S. candidates for the job, and if you get qualified U.S. candidates for the job, that stops the process. So it may not be a good time to start the process for an employer.
Okay, allow me to translate that, and then we'll talk a tiny bit more about Schedule A. El segundo paso del proceso se llama obtener la certificación PER. Los enfermeros en particular están precertificados, pero esto es importante que ustedes entiendan que un empleador en los Estados Unidos no simplemente puede empezar a decir yo quiero traer en personas de otros países. Ellos tienen que demostrarle al gobierno a través de este proceso, el proceso PERM, de que hay una escasez de esos profesionales o esos individuos en el mercado laboral. Es un proceso que requiere tener que Kevin nos explicaba, por lo menos hacer 3 publicaciones en el mercado laboral, buscando que no hayan ciudadanos americanos o residentes o personas que tienen permisos laborales actualmente en los Estados Unidos que no pueden llenar esas vacantes. Es importante también que se sepa que a veces los empleadores no lo quieren hacer porque en ese momento en el mercado puede ser que las condiciones del mercado no sean favorables para hacer este tipo de ofertas. Okay, I think I did a fair translation of all your good explanation. Let's talk a tiny bit extra about scheduling. What does that mean that a job is pre-certified? Well, and you mentioned nurses and excuse me, as an
Physical therapist.
physical therapist, excuse me, I was blanking out for a second. Who else? You may want to maybe mention a few other ones, but what exactly is a Schedule A?
Yeah, so Schedule A means that the United States government has determined that there is a shortage of qualified workers for a particular occupation. So they've determined that there is a shortage of qualified U.S. citizen, green card, refugee, and asylee nurses in the United States. And so because there's a shortage of nurses, that they don't have to go through that process of doing their recruitment. We've already determined that there are not enough. And so they are what they call Schedule A occupations, and those Schedule A occupations get to skip that recruitment step.
It's kind of like they are exempt of having to go through this step.
Exactly. They get exempt from having to test the local labor market to demonstrate that there are not enough minimally qualified people in that profession, because they've already determined that based on the numbers.
Let me translate this piece, and then I'm going to ask you a small detail, because we get asked this question often related to certified nurse assistants, CNAs, because some people wonder about that, but let me translate this piece.
Sure.
Yo le preguntaba a Kevin que nos explicara un poquito qué significa eso del Schedule A. El Schedule A es una precertificación que existe donde hay ciertas ocupaciones, particularmente enfermería y terapistas físicos, que ya el gobierno tiene demostrado de que hay una escasez nacional de estos individuos. Por lo tanto, Estas profesiones que ya están revisadas, ya están autorizadas por el gobierno, están bajo este Schedule A, no tienen que pasar por el proceso de precertificar la necesidad local. Eso es una de las ventajas y uno de los motivos por los cuales enfermería no pasa por este segundo paso. Kevin, a lot of CNAs think that they are equivalent to a nurse and they wonder how come people is not recruiting them. And I often tell them there is a demonstrated shortage of nurses, not a demonstrated shortage of CNAs. A hospital who wants to recruit CNAs have to demonstrate to the government through the PERM process that there is effectively a shortage of those individuals in that local market. Am I correct on that?
You are correct. So the occupations that qualify for Schedule A are professional nurses, which are registered nurses and physical therapists. And then there's a subcategory for those who are experts in performing arts, the sciences, or university teachers and professors. Those are the group of categories that qualify for the Schedule A distinction, and our CNAs they don't qualify as professional nurses who require a nursing license in the United States. And so they are not Schedule A. You can get a green card for those positions, but they are not Schedule A. They have to go through the normal PERM process.
Entonces yo le pedía a Kevin que por favor nos explicara un poquito porque nos preguntan con frecuencia algunas personas que no son licenciados en enfermería, que no tienen un título equivalente a una profesión, o un título profesional en enfermería, porque es que ellos no los incluimos. Estos trabajos no están categorizados como que hay una escasez de ellos en los Estados Unidos. Para que un empleador quiera traer ese tipo de profesiones, como muchas otras profesiones, tiene que pasar por este segundo paso, que es demostrarle al gobierno que en el mercado de ellos tienen una necesidad local y muy pocos empleadores se encuentran en esa situación. Okay, Kevin, I think that kind of exhausted a little bit the issue of the perm. Let's talk a little bit about the filing for the I-140, okay? I think this is something that a lot of people hear about I-140s, I-140s, I-140s. They don't really understand that. So let's give them a quick explanation what that means.
Sure. So the third step in the process, if you're dealing with a position like a nurse, Schedule A nurse, you file your pre-certified 9089 along with your I-140. And the I-140 is your immigrant petition. Essentially, that is the documentation to the USCIS that you qualify for the position and that there is a position available for you, and you meet those qualifications. And so it's really the application for the green card. We have a person who meets the qualifications to receive a green card, and we have a position for them. And so they file an I-140 with the USCIS, and that petition includes information about the hospital or the employer if it's a non-hospital situation, and it includes information about the foreign national, so their credentials, maybe their transcripts, their degrees, information about where they've lived, so birth certificate, passports, and it is sort of the final piece of evidence that the USCIS needs to determine whether or not someone is qualified for the actual position.
Okay, so yo le preguntaba a Kevin, todo el mundo oye sobre el proceso I-140 y 140, que nos explique un poquito. Obviamente una vez que la posición, el tipo de trabajo está certificado, el empleador con esa certificación obviamente hace una petición formal al Departamento de los Estados Unidos de Inmigración para demostrarle que él tiene una persona extranjera que absolutamente cubre los requerimientos de esa posición. Durante cuando se hace esa petición formal que se hace a través de la forma I-140, hay que entregarle un conjunto de documentación al gobierno porque es el paso final, formal, donde se demuestra que la persona a la cual se le está extendiendo el empleo cumple los requerimientos de esa posición y cumple los requerimientos de la certificación que se está ofreciendo. Muy bien. So, Kevin, just briefly, almost with no exception, most employers do pay for premium processing. And why is that?
Premium processing will expedite the process for getting an I-140 approval. And so most employers, just as a practice, will premium process a petition so that they get that I-140 approval for the nurses quickly. And premium processing guarantees that the USCIS will review a petition within 15 days of submission. So it'll get an expedited review of the petition as opposed to regular processing, which means that an officer likely isn't going to review the petition for about 7.5 months right now.
So, le pedía a Kevin que nos explicara un poco que por qué es que la mayoría de los empleadores están pagando por el proceso acelerado o el proceso Premier. Es porque obviamente esto le garantiza a ellos que el caso que ellos están entregando al Departamento de Inmigración se va a revisar en las próximas 2 semanas. En los próximos 2 semanas lo van a revisar y van a tomar una decisión al respecto. Si no se pagara por el proceso acelerado, esos procesos en este momento, Kevin nos comenta, están durando casi 7.5 meses para que obtengan una aprobación una revisión del Departamento de Inmigración. So, Kevin, I think we can now move to the last 2 steps, and I think the next one is probably a little bit more of the sticky part. So, you go through I-140. Officially, your visa, your case has been approved. You are good to go. You are officially, the employer has everything that is meant. So now what happened next? Everybody thinks, okay, if my I-140 is approved, I'm done. Well, not really.
No.
So
Yeah, I wish that was the case. Your I-140 is approved, and that means that the USCIS has determined that you qualify and are approved for a green card when one is available to you. And so that sort of preserves your spot in line. There's a green card available to you. But the next step in the process is waiting for that green card to actually become available. And probably as why everybody is here, a lot of people are here today, is that visa bulletin that comes out and determines when a visa is available for us. So really, after the I-140 stage, generally the next step is at the National Visa Center. If you're outside the United States, the National Visa Center is going to send us an email that says that you can now pay your National Visa Center fees, and they'll have a list of documents that you need to send. Sometimes.
allow me to interrupt you there for a second. Sure. There's so much information I don't want to miss, so I'll interrupt you for 1 second. So, lo que yo le preguntaba a Kevin, ok, si ya tengo mi visa, mi visa oficialmente aprobada por el Departamento de Inmigración, ¿por qué no me la dan inmediatamente? Y desafortunadamente, y todos quisiéramos que con el I-140 se hubiera acabado el proceso. Desafortunadamente, el hecho de que tienes tu visa aprobada no significa que hay una visa disponible. Tienes que ahora pasar al siguiente paso, que es ir al Centro Nacional de Visas, a que ellos oficialmente te adjudiquen, del banco de visas te adjudiquen una visa para que te la puedan dar. Obviamente hay que llenar un conjunto de papeles, pero ahorita estás a la merced. Y Kevin mencionaba seguramente muchos, uno de los motivos grandes porque algunos de ustedes están aquí en la reunión, es este paso de esperar a que se les adjudique la visa. Tiene que ver con los bancos de visa. So, let's expand a tiny bit about that issue of the uh, being given the visa, the number of visas, how a little bit of how that process controls. Can you immediately ask for the visa to be given to you and just wait? I know you are in queue, or you can still ask the request. How does that work? A little bit, a tiny bit on, a little bit extra on.
Yeah, so sort of the first step, okay, after your I-140 is approved, the case gets forwarded to the National Visa Center, and in situations where green cards are immediately available or are available usually around within the next 12 months, then they will collect the fees and they'll allow you to start sending your documentation in. When you have situations where there's significant retrogression, like we're in right now, the National Visa Center will send communication that they've received your case, but they will say, we're not going to collect your fees and documents right now until the retrogression gets better. And the reason behind that process is generally when the National Visa Center gets your case, they want to clear the case out within 1 year. And so if your case is, if the current visa bulletin shows that it's going to take longer than a year, they usually wait to collect those fees and those documents a lot of times, because some of those documents are only good for a year. Like your police clearance might only be good for 12 months. So it doesn't make sense for us to collect it now and have you have to come back and do it again. So that's sort of the first part of the process.
Allow me to
But
translate that first, if you don't
sure.
mind, and we'll talk about the second part. So, cuando la visa queda aprobada, inmediatamente se manda al centro de visas. Normalmente, si el tiempo para adjudicar la visa es menos de un año, el centro de visas dice, y obviamente ellos siempre informan que han recibido el caso aprobado, y en esas situaciones les dicen a la persona, ya puedes empezar obviamente a pagar lo que vale a ser el proceso, y no solo eso, sino empezar a enviar tus documentos al centro de visas para que te den la visa. Normalmente, si el boletín de visas dice que hay una demora más larga de un año, normalmente normalmente les informan a los abogados, hemos recibido el caso, pero no nos envíes nada, no nos pagues ni nos envíes nada hasta que el boletín no te informemos que el boletín ya está más corriente, porque alguna parte de la documentación, por ejemplo, Kevin mencionaba, la cuestión de no tener ningún proceso legal o alguna cuestión que te pueda impedir eso. No, son documentos que no están válidos por más de un año. Así, por lo tanto, la intención del Centro Nacional de Visas es que durante el año que ellos empiezan a recibir la documentación, ellos procesan tu caso. Okay. So the
Yep.
second part you were going to mention.
Yeah, so the second part of it is sort of that there are only so many visas available in a particular year. So for employment-based visas, there's at least 140,000 employment-based visas available per year. And that is sort of the baseline. If there are unused family-based visas, then they'll toss those to the employment-based side. So for example, for 2024, they're anticipating 160,000 employment-based visas available. But no more than 7% of those visas can be allocated to a particular country. And because of the cap on the number of visas plus the cap on the per country quota, it's created a backlog because the demand for visas has exceeded the amount of visas, and with that, they've created the visa bulletin, which comes out every single month and tells us whether or not a visa is available to a particular person.
Okay, perfect. Let me translate that. Thank you, Kevin. So,
Yep.
anualmente para las visas para empleadores hay un mínimo de por lo menos 140.000 visas que se ponen anualmente para los procesos de los empleadores. ¿Ok? Este número es el mínimo porque con frecuencia hay más, porque cualquier exceso en visas en la parte de familia o en otras partes, estas se adjudican a los empleadores. Por ejemplo, este año van a haber aproximadamente unas 160.000 visas disponibles para los empleadores. Pero de esas 140.000 visas o las que hayan disponibles, ningún país puede recibir más del 7% de esas visas. Por eso el boletín de visas dice que países tienen exceso de peticiones y por lo tanto pueden demorar más el proceso. Ahorita vamos a hablar del boletín de visas, pero entonces hay dos restricciones. Una es el número total de visas disponibles para ese año y la segunda parte es obviamente el número de visas que se le pueden adjudicar a un país específicamente. Okay, so I think that explains a little bit of that process. So, okay, so let's say I'm good. My visa, the National Visa Center say, hey, Kevin, David Letter Schneider visa, we have it. It's good. We're ready to move to the next step. So what comes next? I not only have my 140, I already have my visa um, being I've been given my visa. So what's next?
So if you are abroad, if you're outside of the United States, you would process at the U.S. consulate in the country that you're in. So the U.S. consulate in that country would, the National Visa Center would tell that consulate that they have all of your documents and that they are free to schedule you for an interview. And that nurse would go to that U.S. consulate for an interview, and they would bring all of the documents that are required to that interview, and they would have an interview with an officer at the consulate. If it, go ahead.
No, if you, I wanted to explain the consular piece. If you has anything else to say, I'll stop for a second.
No, and so it's a communication from the National Visa Center gives a candidate the all clear that they're documentarily qualified, and then from there, once the National Visa Center lets the consulate know that that a candidate is documentarily qualified, they will schedule them for an interview at a later date, and then the nurse shows up at the interview.
Okay, so una vez que el Centro Nacional de Visas adjudicó tu visa, el proceso hay dos rutas a seguir. Uno es si la persona está por fuera de los Estados Unidos, va al proceso consular. En este momento, el centro de visas le avisa al consulado que la persona tiene toda su documentación y su visa recibida para que ellos puedan pasar al paso final, que es obviamente pasar a la entrevista consular que se hace en el país. Normalmente, obviamente, la entrevista consular requiere traer algunos documentos tradicionales. La mayoría ya están en manos del consulado, pero van al paso final, que es la aprobación final de la visa, que se hace a través del proceso consular. Kevin, I wanted to leave clear for everyone that even though your I-140 has been approved, your visa has been officially approved, and even though you have been allocated a visa through the NVC, the final say rests with that consulate. That interview can go, sour, in other words. I think it's important that people understand that the consular process is the final check of the process, and they have a lot to say if they don't feel that has been allocated properly, and they can actually stop the complete process. So do you want to add a little bit about that?
Sure, absolutely. So if you are consular processing, a United States consular officer has the power to determine who gets admitted to the United States. They have sole discretion. So even if the USCIS is determined that you qualify for a visa, and one's available to you, if that consulate officer determines for some reason that you are not qualified for a visa or there's something that you didn't do, they have the sole discretion to choose to either approve you for that green card or to deny that green card or to put you in administrative processing.
And we'll talk a tiny bit more about administrative processing. So es importante que ustedes sepan que a pesar de que su visa puede estar completamente aprobada y su visa ha sido entregada a usted, el paso final es completamente a la discreción del cónsul de tomar la determinación final de entregarte la visa o de negarte la visa. En realidad hay tres categorías, obviamente que te la aprueben o que te la nieguen, pero hay un tercer paso que es que te la ponen en pausa administrativa y que nos va a explicar una botica qué significa la pausa administrativa. So let's talk about that administrative
Sure.
pause.
So administrative processing is not an approval or a denial. It is there is something for some reason, usually something in someone's background that there are additional questions about. It may be past immigration violations or issues. It might be questions about where you've lived abroad, additional questions about your travel. There could be security clearance issues. There are a number of issues in which an officer might have additional questions. And so in order to satisfy that officer to approve you for a visa, they want to look into some of these additional issues. And so they may put you in administrative processing and they may require you to get updated documents or, they may ask you for additional information about a particular area. I've had administrative processing for questions about frequent travel. Why are you traveling so much? Where have you lived? Give me the information about the places that you've lived for, over 6 months going back until you're 18. And it's just to make sure that they have done that final background check before they decide to give someone a green card to come to the United States, because they're really doing their job, that final check and balance of whether or not there's anything in someone's past that would make them inadmissible to the United States. So it isn't a denial. It just takes some additional time for them to check into the background or particular issue.
And this is something obviously that is done concurrently with you guys. The lawyer and the candidate are usually working side by side to respond to whatever consular issues may be pending, correct?
Absolutely. So if you get placed in administrative processing, they will give the candidate information about why. So usually they'll give them a piece of paper and it'll say why, and they'll tell them what it is in their background or what information that they need to continue to process that visa. From there, usually we have a conversation with the foreign national to figure out why they're placed in administrative processing and to address the officer's concerns, to get the documentation that they need, to help them fill in any details that the officer needs. And so we'll work hand in hand with the nurse in order to make sure that the issues are addressed.
Okay. So, cuando una persona entra en el proceso administrativo no significa que te negaron la visa. Obviamente no te la han aprobado, pero no te la han negado. Normalmente lo que significa es que el cónsul tiene algunas preguntas adicionales o hay algo en la información que ellos quieren tener más detalles o quieren actualizar esa información. Situaciones comunes es donde la persona ha viajado bastante, quieren tener más información sobre a dónde la persona ha ido y algunos de los motivos y cuánto tiempo pasó en algunos de esos sitios. Algunas cosas tienen que ver con alguna clarificación. Normalmente, cuando esto sucede, el candidato es informado en detalle qué es lo que exactamente tienen preguntas, quieren clarificaciones adicionales y esto es algo que obviamente con ayuda del abogado van a someter, le van a entregar al cónsul para finalizar el caso. Would you say that most of the time the questions can be answered satisfactorily, or is this a process that not always end up as, or more often than not, it does not end up as successful as you would like it to be?
I would say more often than not, it ends up in success. So, um, generally, it is clarifying some particular issues in a background or getting updated documentation. And so, generally, it's something that is readily cleared up. Where sometimes you can run into issues where it doesn't get cleared up is when someone hasn't been 100% truthful
Mhm.
on the front end, either, both with the officer and sort of with the attorney about something that's in their background. And then that comes up and there's nothing that, anybody can do because they didn't know about that particular issue. So those are the rare cases in which administrative processing, someone gets put in an administrative processing and it doesn't end up being a successful result. It's usually there's something that was in their background, whether it's usually something that makes them inadmissible to the United States, something criminal, something where they had maybe a deportation and then a reentry, something like that wasn't disclosed on the front end, and now it's been discovered.
Ok. La gran mayoría de los casos administrativos resuelven positivamente una vez que la información adicional ha sido dada. Obviamente hay algunas situaciones en las cuales no se resuelven positivamente. Normalmente es algo que la persona, el candidato, no le comentó al abogado de antemano, cosas que hay que tener en cuenta que pueden descalificarlos para recibir una residencia, una entrada permanente a los Estados Unidos. Es importante que esos detalles se hayan discutido con el abogado, así hay bastante certeza de que el caso no va a tener ninguna omisión. Let's talk a little bit about the adjustment of status, and then I'll ask one last question about the consular processing, about the family piece, or we can talk about that when we talk about the family portion. So
Sure.
let's talk about adjustment of status. What does the second part means?
Sure. So if you have an approved I-140 and you're currently in the United States in a valid status, so if you have some other type of visa and you're in the United States, and your priority date becomes current, you can file an adjustment of status instead of consulate processing. So concept processing, you're outside the United States and you process outside the United States. Adjustment of status, you're inside the United States in a valid status. And instead of going outside to have your interview and doing your medical exam outside the United States, you submit your paperwork to the USCIS and you process within the United States. So the requirements are all still, the same. They still do the medical exam. They still check your background, but instead of going to a consulate outside the United States, you're filing a I-485 with the USCIS, and both processes result in a green card. It just depends on, are you inside the United States and are you outside of the United States, and whether or not you're in a valid status.
And you still go through an interview like on a consul, you're just doing it inside the United States.
So yes and no. Sometimes you do and sometimes you don't. They used to do everybody has to go for an interview. They have been in some cases saying, based on the information that we see, you don't need to come for an interview and just granting the 485s. So there is a chance that if you filed an adjustment of status that you wouldn't have to go for an interview.
Okay, that's good to know. So, el segundo caso, obviamente, es aquellos que están bajo una situación legal propia en los Estados Unidos. En vez de tener que ir por el proceso consular, el paso final se puede tomar dentro de los Estados Unidos, haciendo un ajuste del estatus. Una persona que estaba acá como estudiante o con una visa de trabajo o con algún otro tipo de permiso formal, legal, en los Estados Unidos, se hace una aplicación un poco diferente donde se pide un ajuste de estatus. la ventaja un poco de esta situación es que no todo el mundo tiene que pasar por una entrevista, como en el caso consular, en algunas instancias sí. Hoy en día, algunas situaciones, porque como ya se tiene información sobre la persona, el proceso de ajuste de estatus puede no requerir una entrevista y simplemente se les entrega la residencia permanente. So I think we pretty much gave a very good overview on this, Kevin. I think we can, unless there is something in particular that you may want to add, I would like to kind of move to the next topic.
Sure.
Is there something about this process that that we kind of left out? I think we gave a good explanation about the process itself.
Yeah, the only thing I would say is that is sort of the step that where your dependents come in. Is that sort of you include them on the I-140. They will, if they're a consulate process, they'll process with you at the consulate. If you're filing adjustment of status, they have to file their own adjustment of status. That's the only thing I would say.
Okay, good. We'll talk a little bit about family in a second, a little bit more. So
Perfect.
I just wanted to do 3 additional details about these considerations. Could we say a little bit something about the famous visa screen? If you want to say something a little bit about that. Carrie and I will say something about the licensing, obviously to practice in the state that the employer is. And here may be the first time that we can talk a little bit about the timeline related to the process. So let's talk a little bit about the famous visa screen. Why the document and when do you need it?
So you need the visa screen. Certain healthcare occupations require you to have a visa screen, and essentially it is making sure that there is a proficiency in English and that the education that you've received is comparable to the education for the position in the United States. And so you will need to make sure that you get that visa screen so that you can work in the United States in a RN position. I think there are 8 healthcare positions that require visa screens, and so you need to have that visa screen when you are coming to the United States. So it's not something that you need necessarily at the I-140 filing stage, but when you're sort of to that, I usually like to say when you're to that interview stage where
The
that you
consular
need to make sure
stage.
that you have that visa screen, because at that point you're to the process where you're going to get ready to be admitted to the United States.
Oops, sorry, I didn't mean to move ahead. Sorry about that. Let me go back. I apologize. So Kevin, 3 consideraciones adicionales que es importante que sepan. Hay algunas profesiones en el área de la salud, particularmente el área de enfermería, que las personas no pueden obtener su residencia en los Estados Unidos sin demostrar que tienen las equivalencias. Hay 8 profesiones, enfermería es una de ellas, que tienen las equivalencias profesionales que se requieren para ellos. Para demostrar esas equivalencias, el único documento que demuestra, que certifica que eres equivalente, que tienes un título equivalente y que tienes la capacidad de hablar el idioma, se llama el Visa Screen. En realidad, el Visa Screen no se necesita para comenzar el proceso migratorio, pero no se puede terminar sin tener el visa screen. En realidad no se puede ir al proceso consular sin tener ya un visa screen completamente, no, sin haber obtenido completamente el visa screen. I wanted to add something to this part, and obviously, Carrie, don't hesitate to pitch in on these 2 subjects, which is right now, almost all employers, especially with nurses coming from certain areas of the world, particularly Latin America, are very skittish if they don't know that they already have passed the English proficiency. They worry that even though they can start and they pay obviously good money to do all the immigration process, that the immigration process come to a crash because the person is not able to pass the English proficiency test, and it just cannot move the process any further. So it has become quite routine that the employers will not entertain starting a immigration process without the 2 proficiency tests being passed. Do you care, Kevin and Carrie, do you guys want to say something else? Allow me to translate that piece first and then we can talk a little bit more about that. Es importante que todo el mundo sepa de que la mayoría de los empleadores en el área de enfermería anteriormente permitían que la gente continuara el proceso y entregara después su examen de inglés pasado. Pero debido a que mucha gente ha tenido problemas, sobre todo en ciertas secciones del mundo, particularmente los enfermeros latinos, la gran mayoría de los empleadores no están interesados en hacerte una entrevista y empezar a pagar cientos y miles de dólares por tu proceso si no tienen certeza de que has pasado el examen de inglés. ¿Ok? So I don't know, Carrie, if you want to add something to that, or Kevin.
So that's correct, David. The hospitals are requiring that the nurses have passed their NCLEX RN and also that they've passed their English proficiency test in order to receive an interview. Because the hospitals are very motivated to hire international nurses, they want to make sure that they can meet all of the qualifications before they start paying for the immigration attorney, the immigration fees, and so on. So that's a true statement. It really is something that must be done. And it's also a benefit to the nurse. Many nurses have told us, no problem, I can just easily take that test. And sometimes it does take more than one try, and it's less pressure for the nurse if they just get their qualifications before they start the interview process.
Terry nos comenta que obviamente lo que yo les comentaba es correcto. Los empleadores obviamente están muy deseosos de traer a la mayor cantidad de enfermeros. Ellos quieren tener cierto nivel de certeza de que no van a haber impedimentos adicionales en la parte del proceso. Así que casi sin excepción, por no decir sin excepción, los empleadores están exigiendo que vengas con los requerimientos completamente pasados para que ellos puedan acelerar el proceso lo más pronto posible. Kevin, is there anything else you want to say about this subject, or can we talk a little bit about the licensing, Carrie, the issue of the state licensing?
I think Carrie can talk about licensing. I'm all set.
Yeah, okay.
Okay. So everybody will need to obtain a license for the state in which they are going to practice nursing. So you can get your NCLEX RN in really any state. You can determine where you want to get your license, but it's very common that people need to endorse their license to the state where they're actually going to practice. And some states allow you to do that while you're waiting for immigration, and others require that you must be in the United States and have a social security number before they will allow you to endorse your license.
Okay, allow me to translate that. Obviamente, ustedes obviamente habiendo pasado por el proceso de certificación, pueden haber obtenido una licencia de cualquiera de los estados. Obviamente las licencias se endorsan se certifican, se endorsan de un estado al otro. Hay algunos estados, el estado donde vas a terminar trabajando, que a veces permiten hacer el proceso. Cuando todavía estás haciendo el proceso consular, se puede endorsar la licencia. Otros estados no permiten hacer el endorso hasta que no has recibido tu tarjeta de la seguridad social, del Social Security, para poder hacer el endorsement. Es súper importante. Carrie, I don't know, you were going to mention this, the issue of English about from one state and the test of English that is taken for the license endorsement. You want to talk a little bit about that?
I do. So some people can get a license that doesn't require a language requirement. There's some states that don't require that. Every state has their own requirements related to language. And so what we try to mention to people is that TOEFL and IELTS are the two tests that are really accepted in almost every state. So if you're planning on taking a language test and you only want to take it once for immigration and once for licensure, consider TOEFL or IELTS. They are accepted for licensing everywhere. Some people take a different language test that is good for your immigration, for the visa screen, but it doesn't work for the licensure in the state. So be cautious about that and consider if you only want to take that test one time, take the TOEFL or the IELTS.
So what you're saying is that they are at risk to having to retake again TOEFL and or IELTS for the state that they are actually going to end up working.
That's correct.
Okay. So,
Yeah, thank you.
So, por favor, recuerden lo siguiente. Para efectos de migración, hay un grupo grande de exámenes de inglés que se pueden tomar. Todos son válidos. El TOEFL, el IELTS, el PET, el OET, el MET, etcétera, etcétera. Eso no significa que cada estado tiene sus propios requerimientos y los exámenes de inglés y sus requerimientos son estado específico. Si tienes una oferta laboral en un estado y ese estado no acepta, y muchos estados no aceptan muchas de las pruebas de inglés, sino solamente ciertas, significa que vas a tener que volver a tomar tu examen de inglés específico para ese estado. Por eso, la recomendación general, y todos sabemos que obviamente algunas personas consideran que unos exámenes son poco menos complicados que otros. En realidad hay solamente dos exámenes, en particular uno, el TOEFL, se acepta en absolutamente todos los estados. El IELTS en todos menos uno, ¿ok? El siguiente es el OET y de ahí en adelante el grupo de los exámenes tienen limitaciones y depende cómo cada estado maneja la cuestión del inglés. Puede ser que para poder endorsar tu licencia a ese estado, para poder trabajar, te va a volver a tocar tomar una prueba de inglés. Nuevamente, eso tengan eso en cuenta. Por eso el asunto del endorso de las licencias, porque muchos de ustedes se licencian en estados que ni siquiera requieren inglés. El estado de New York, estados como Montana no requieren inglés. Se puede hacer la licenciatura y obtener su licencia de enfermería sin tener el inglés. Obviamente sí se requiere un examen de inglés para el visa screen. No se puede seguir sin el visa screen. Y recuerden que para el endorso de la licencia de Nueva York o de Montana o de Wisconsin o de Texas se requiere tener los requerimientos del nuevo estado en el que vas a endorsar la licencia. Okay. I think we already talked a little bit about the timeline. We're going to talk some more about the timeline. So I'm going to move to the next topic. Kevin, let's move. So let's talk about family. Hablemos de la familia. Let's talk about family. Okay. So Kevin, standard question. Everybody wants to, if they have a family, they want to bring their family. So who can come under an employer-sponsored visa?
So any spouses, so they have to be lawfully married. Oftentimes we have people say, this is my husband or this is my wife, but they're not actually married. So lawfully married spouses and our children who are under 21 who are unmarried. They are going to be able to be derivative beneficiaries of the applicant's petition.
So, el proceso de la visa de residencia a través del empleador permite traer a los beneficiarios derivativos, lo que con frecuencia nos referimos como el núcleo familiar. Estos son el cónyuge casado, legalmente casado. Uniones libres no funcionan, tienen que estar legalmente casados, no importa el sexo del cónyuge, y a los hijos solteros, no casados, menores de 21 años. A ellos, por extensión, por derivado, obtienen su residencia permanente a través del proceso también. So, two important considerations I want to make sure that people always want to know with respect to this. If people is on a union but not officially married, can they wait until the very last minute to get married, or no? How far ahead should they get married before we start all this process? Because I usually tell them, you cannot get married the day before you want to file. You're not going to file the documentation you're going to need to be able to file as a family. So some people want to delay kind of until the last minute. What will be a decent amount of time? 3 months, 6 months?
I think it probably varies by country and how long it's going to take to get the documentation, but I would say 3 months seems sufficient to me in order to get the documentation right. You're going to have to provide proof of with a marriage certificate that you're married, and so how long? And if you're considering that, I think the question to ask sort of your local government is, how long is it going to take me to get a marriage certificate after we're married? Because you're going to need that document. But I would suspect that 3 months is enough time to get that document in most countries.
And before I translate that, the standard question people ask, does it has to be a civil union, or does it has to be a religious union? Oftentimes in some of the Latin countries, everybody thinks that it has to be a religious union, the only thing that counts. But no, for the United States.
It doesn't have to be religious. It has to be a marriage that is recognized in that particular country. So oftentimes, in various countries, a religious union is one of many ways at which a marriage is recognized in that country. And so as long as that marriage is recognized in that country as a lawful marriage, it can be recognized in the United States.
Entonces, si estás en una unión libre, ¿qué tan pronto tienes que casarte? La respuesta depende un poco más de tu país que de los Estados Unidos. Lo importante que sepan es, tienen que tener su certificado legal de que están casados legalmente en el momento de hacer la afiliación para entregar los papeles para su certificación. La segunda pregunta es que nos hacen con frecuencia, que si tiene que ser un matrimonio religioso o civil. La respuesta es muy fácil. El proceso es un matrimonio de que están casados legalmente, que reconozca tu país, si es religiosa o si es no religiosa, tiene que ser oficialmente aprobada en tu país. Eso es lo único que cuenta. And we're going to go to the sticky questions of children under 21. So sorry, I cannot jump to the next slide. Okay, so we know that you will be filing together, or that you can file together or separate as a family. And Usually, this is a consideration that the family can make, but what would be your recommendation, Kevin?
I usually recommend that people do it together just because I think it's easier. I think going to the consulate, interviewing together, submitting the documentation together, I think that's just easier for everybody to gather the documentation together and to go together. I think there are times when families don't do that. Oftentimes it might be one spouse is staying for a little bit to work, or maybe it's in the middle of the school year, and so they don't want to move in the middle of the school year, and so sometimes they'll process separate. But I think generally speaking, doing it together makes the most sense. I think it's just easier.
Okay.
Your cases are sort of linked together, and you can do it all together.
Okay, and the often question, there may be a question mark on the spouse or something like that where they could legally apply. So it's not instant that just because we are married that the visa can be extended to the spouse. If there are any legal issues or things pending with that spouse, you could be granted your visa, but your spouse will not be granted the visa.
Absolutely. There are reasons why a spouse may be denied a visa. They may be ineligible. Maybe they got deported 10 years ago, and then they came back to the United States without serving their bar. That might mean a spouse is not eligible. So certainly one spouse may be eligible and another spouse may not be, usually based on immigration violations or criminal violations. Your spouse may have committed a violent crime before and served time, and so that crime may make them ineligible for a green card.
So, es importante que en general la recomendación es que la familia haga su documentación toda simultáneamente. Obviamente hay algunas circunstancias donde tiene sentido hacer el de la familia un poquito más adelante que el de la persona. Eso es obviamente una circunstancia individual que vale la pena discutirla de antemano. Lo otro que discutimos con Kevin, para que a ustedes les quede claro, es no porque uno esté casado, significa que automáticamente el cónyuge va a recibir la residencia permanente. Hay circunstancias por las cuales el cónyuge puede ser no elegible, no se le puede dar, no se le puede extender la visa. Pueden haber problemas migratorios, que tuvo problemas legales migratorios anteriores en los Estados Unidos, o que la persona tiene alguna cuestión criminal que lo vuelve, que no le va a permitir obtener una residencia en los Estados Unidos. Eso no significa que al enfermero, la persona que está haciendo, no se la vayan a dar. Eso significa que al cónyuge no le van a extender esa visa. Esto es algo que obviamente en algunos casos particulares, esto pasa pocas veces, obviamente es una cosa que hay que discutir de antemano con los abogados, ¿ok? So, work authorization for spouses. Kevin, can we say a little bit about the EADs?
Yes. So if you are filing an adjustment of status, you can, at the same time as you file that adjustment of status, file for an employment authorization document for your spouse. So spouses are eligible for work authorization while that green card is being processed. If your consulate processing your spouse and your spouse is coming with you, they're going to get the green card at the same time as you, and so they're going to be able to have work authorization as well. But for those who are adjusting status, there is an opportunity for their spouse to file an employment authorization document and work in the United States while the green card processes.
Ok, thanks. Para aquellos que están haciendo obviamente el proceso dentro de los Estados Unidos, una vez que se hace la aplicación para la solicitud del Green Card, de la tarjeta verde, se puede solicitar un permiso de trabajo en ese mismo momento mientras que se esperan las tarjetas, las residencias permanentes. para que la familia, el cónyuge también pueda obtener inmediatamente el permiso, lo que se llama el EAD, el EAD, el que es la autorización el documento de autorización para empleo, mientras que se está tramitando, mientras que se está procesando la aplicación para su residencia permanente. And briefly, the last topic on this is the age out of children. So you file my I-40 today, July the 3rd. My child today is still 20 years old and let's say 11 months. Does that mean I'm clear? Is my child good because we file I-40 before the age of 21, or are we not clear?
So you're not clear. Your child could age out of the process. So even though you filed I-140 when the child was 20 years old and 11 months, if there's not a visa available and because of retrogression, your child may age out. There are some exceptions. Um, there is an act, the Child Status Protection Act, that will subtract the number of months that you waited for your I-140 to be processed from the child's age at the time that the your green card became available. But in situations like where you've premium processed, um, then that's only going to be like 15 days. You know, if it was a regular processing situation and regular processing took 7 months, you would be able to subtract 7 months of time. And so, depending on when that visa became available, you may have an additional 7 months beyond the 21st birthday. But generally, your child is going to age out of the process once they get to 21. And so you want to make sure that you're factoring that, you're considering that on the front end, whether or not you want to bring your child, then starting the process earlier is always better.
Yeah. And Kevin, before I translate, when do the age gets officially frozen?
So their ages. So do you mean for Child Status Protection Act purposes?
Yeah. As soon
So
as NBC says you can send the paperwork, is the age officially frozen at that point in time?
yeah, so it's the term is when you seek to acquire status. So that is when you uh make contact with the NVC, or if you're adjusting status, when you make contact with the USCIS.
But when I make contact with NBC, when they give you permission to make contact with them, when they say, I would receive your application from the I-140, sit tight, you cannot make contact with that yet. This is the moment that you can officially pay for the NBC process, correct? Is that what that means?
So that's how it's supposed to be. There have been some cases, and there's some case law in which people have argued I made contact with the NVC before I was able to, and so my age is frozen at that point. So there is an argument to be made that by simply making contact with the NVC, even if you're not able to pay, or that you've made contact and your age is frozen.
So Kevin, just so we're closer to that, in theory, what you're saying before I explain this to people, my I-140 got officially approved today, even though the visa bulletin may say you cannot send paperwork yet for your case. We are on whatever, 18 months behind. The fact that you go ahead and make contact with NBC with that file, will that clear that child to have their age freeze? Is that what we're saying?
So I wouldn't say that. I say that there have been cases in which that has worked. It is not the rule, and so it is supposed to be when you pay the fee and file the application. There have been exceptions to the rule in which a visa was not available and the applicant was able to successfully argue that I made contact with the NVC by sending in my application and fee, despite not being there not being a visa available. And I would say it has worked in few cases, but it is not the norm.
It's not a guarantee that it will work.
It's certainly not a guarantee, and it took years of litigation in order to have the government accept it in those limited cases.
Okay.
So
So it's not a guarantee.
it's not
So there
impossible, but it is not the norm.
no, so in reality, is the moment that you are allowed to file to NVC, the moment that age gets frozen, even if there is further retrogression at that point in time, officially NVC allow you to do the filing, you are on the clear at that time.
Right. I mean, that's the reality of it.
That's
Yes.
the reality of it. Okay, allow me to translate. So, con respecto a la edad de los hijos, recuérdense que los hijos tienen que ser menores de 21 años. La edad de 21 años cuenta solamente después de estar aprobado el proceso I-140 y con el permiso del Centro Nacional de Visas, de que puedes mandarles la aplicación en ese momento, se congela la edad de la persona, aun si la visa se demora un año o se demora más, la visa. Si el Centro Nacional de Visas no te ha dado autorización, en principio no está congelada la edad de tu hijo o de tu hija. Hay algunas excepciones, mencionamos brevemente, algunas personas que han mandado la documentación y han inclusive pagado, aún de que no les habían dado permiso de mandar la documentación. Y han habido casos donde se han hecho excepciones para poder congelar la edad, pero obviamente requiere algo de litigación, no es una garantía de que lo vayan a aceptar. Okay, I think we more or less gave that. So now we're going to talk about the final, maybe topic of the day. There are a million questions in the chat, but I'm not sure we'll entertain them all. I may selectively pick up one or two, but let's talk about what everybody wanted to know, which is what is the priority date and what is retrogression. So let's finish with that. So
Sure.
a little bit of an explanation, Kevin, what's the priority date?
So everybody who files an immigrant petition gets a priority date. The priority date is when your petition is properly filed with the USCIS. If you're filing for a Schedule A case, so Schedule A case, like our nurses, the date that the USCIS receives that filing, properly receives a filing with the right fee, that is your priority date. They'll give you your date. That's sort of your place in line. If it is a non-Schedule A position, it's the date in which the 9089 application for permanent employment certification is filed. That is the date that you filed that with the Department of Labor is the date that you get the date. So that is the important thing, is getting a priority date. That saves your place in line.
Okay. En realidad, la fecha de prioridad, priority date, sobre todo para los enfermeros que están bajo el Schedule A, es la fecha en el que la aplicación para su migración ha sido correctamente entregada al Departamento de Migración de los Estados Unidos. Esto inmediatamente te da la fecha que te pone en la fila para la recepción de la visa. En otros casos donde no hay el Schedule A, es el momento en que se ha hecho la certificación, pero para efectos prácticos de la discusión de esta noche, es en realidad la fecha en el que el Departamento de Migración de los Estados Unidos ha recibido tu aplicación del E-140. So, here it is, the infamous visa retrogression before we'll show the chart. So, let's talk a little bit about the visa bulletin and visa retrogression. Let's explain that to everyone.
So each month, the U.S. Department of State puts out the visa bulletin, and the visa bulletin tells us whether or not there are visas available for particular countries and in particular classifications. So EB1 through EB5 or family-based petitions.
So
When
allow me to,
demand
allow me to,
exceeds, go
allow me
ahead.
to translate that for 1 second. Sorry for interrupting you, Kevin.
Oh, you're fine.
El boletín de visas es el que dice en qué situación está el estado de visa, los bancos de visas disponibles. El boletín de visas es el que oficialmente avisas para los diferentes tipos de visas que hay, las de empleadores, las de familias, etcétera, y qué número de esas visas hay disponibles bajo cada una de las categorías. Por ejemplo, en el caso de los empleadores, de las categorías EB1 hasta la categoría EB5, dicen qué disponibilidad hay de esas visas. Sorry.
No, perfect. So every month we have to go to the visa bulletin to determine whether or not a visa is available to us. And so the visa bulletin lists dates at which if your priority date is before the date listed, a visa is available for you and you are able to apply. If your priority date is on or after the date that's listed on the visa bulletin, then you have to wait until you can file your either counsel process or file your adjustment of status. And so it's important every month to look at the visa bulletin and compare that to your priority date because it tells us when we are able to take that final step of either counsel process or adjust status.
Okay.
It changes every single month. It goes forwards and it goes backwards. So that's important thing to know is as you're looking at it, it is going to fluctuate from month to month.
Okay. El boletín de visas es el que oficialmente dice si hay visas disponibles para tu categoría y obviamente para tu país en ese momento. Todos los meses el Departamento de Estado publica el boletín de visas y si tu fecha es anterior a la fecha publicada, significa que hay visas disponibles para ti. Si tu fecha de prioridad es de esa fecha que está publicada en adelante, significa que tienes que mantenerte en línea esperando a que las visas sean adjudicadas. Y estas fechas fluctúan de mes a mes, así que hay que estar siempre pendiente de cuánto hay disponibilidad. Okay, Kevin. So, from the typical retrogression, because it fluctuates from month to month and oftentimes move forward, oftentimes move backwards. If my priority came current and I went ahead and did all my filing and everything was received an MVC and suddenly the next month the process went back, what does that mean for me?
So what that means is that your case is in process because you filed it, but the National Visa Center or the USCIS, they don't continue processing your case. They can't finalize the process. They can't give you a green card until one is available. And if there's retrogression in the middle of the process, you're not going to be able to take that. They're not going to be able to take that final step and issue you that green card until the visa bulletin shows you current again. So just because you filed at one point when the visa bulletin was current, until you receive that green card, if it retrogresses, they can't actually issue a green card to you.
Now, so two questions come to mind. The number one is if I file expedited, that protects me in any way, shape, or form, that the case will move forward quickly and may end up in the consulate sooner. Will that help? And the second
It
part,
certainly helps. So filing, premium processing gets you that priority date sooner. And then if you get your priority date sooner, um, it's, you have a better chance at avoiding retrogression. Now, sometimes it just becomes when we're in a period of time like now with retrogression that is, 2+ years of time. Um, it doesn't say, I don't know that it saves you all that much time, but it certainly is. I think it's worthwhile and it saves you time over regular processing.
mhm,
Um, so I still recommend it.
okay. But so and before I translate, how long does it take for the visa once you file? Let's say you have all the paperwork ready to go. My date became current. You send everything to NBC. How long does it take for them normally to send that to a consular process, assuming that the visa remains current? Can that happen within that month of the visa bulletin? So I'm kind of in the safe side if I have all my paperwork ready to go.
It can. It often takes a little bit longer than that month. And it all depends on consulate volume and consulate backlog. So NVC can certainly send your case to the consulate and let them know that you're ready. But if the consulate themselves are backed up for 2 months or 3 months, they're not going to schedule you for an interview until they have the spots available. So that oftentimes is going to be consulate dependent. So where you actually are going to process. So it certainly could happen. You could get, there's times in which NVC will send your case and maybe it's 2 weeks to get an interview. But what we've seen sort of post COVID is oftentimes it takes longer than, a few weeks to get an interview. It may be
But
a month or two.
but once NBC moves it forward, the visa has already been formally allocated. But if the retrogression occurs, are you subject to the retrogression again
You are until it's been granted.
until it has been stamped on your passport?
Mhm.
Okay, that's what I wanted to translate. Okay. So, permítanme traducirles para que puedan entender. Los boletines de visa dicen cuándo se puede entregarle al Centro Nacional de Visas la documentación para mover tu caso. Obviamente, el proceso de que el Centro Nacional de Visas adjudica la visa, normalmente, aún pagando expedited, normalmente toma más de un mes. Suponiendo que sí tomara un mes y se manda al proceso consular, también estamos dependientes de qué tan rápido el consulado propiamente está dispuesto, a pesar de que se está pagando acelerado, está dispuesto a hacerte la entrevista. Hasta que la entrevista no está oficialmente concluida, la visa no está adjudicada en tu pasaporte. ¿Ok? Entonces, si hay una retrogresión, en teoría podrías estar sujeto a una demora hasta que la visa no se estampa oficialmente en tu pasaporte. ¿Ok? Eso es lo importante que ustedes sepan. Before I show the chart, let's talk, I know we're getting way past the hour. Sorry, we talk so much. Um, when, what happened with the visa banks? 140,000 visas sounds like a lot of visas, tons of visas. 160,000 visas sounds like a lot of visas. Why do they get not taken so quickly, and when do that bank gets replenished?
Sure. So it sounds like a lot, but the demand for them really exceeds the amount of visas, and then you have to remember that it's both by country. And so yes, there are 140 or 160, but no country is going to get more than 7% of those. So that really could limit the amount of visas that are available for a particular country, and so that causes that backlog to occur. Um, the good thing is that the USCIS fiscal year starts on October 1. And so every fiscal year that, 100 at least 140,000 visas gets replenished. And so what we usually see is after October 1, once those visas get replenished, that the visa bulletin starts to then go, instead of retrogress, it starts to move forward a little bit. So that's what I would expect to happen. It may not be immediate, so it may not happen on October 1, but soon thereafter, generally, you start to see some relief.
So, es importante que sepan que obviamente 140,000, 160,000 visas son un montón de visas, pero hay una demanda que excede las visas. Am, eh, lo, em, y también tengan en cuenta lo que les dijimos de que las visas, no más del 7% de ese banco pueden ir a un país en particular. Así que eso es parte obviamente de los boletines, pero eso es parte de cómo se hace la adjudicación. Em, les, lo importante es que se acuerden que cada octubre se completa el año fiscal y entra el nuevo banco de visas del año siguiente. Entonces, obviamente, se regenera el número de visas que hay disponibles para el siguiente año. Entonces, obviamente, hay fluctuaciones en el boletín de visas. So, what I'm showing to everyone, lo que les estoy mostrando a todos es los últimos 10 años. I'm showing everyone the last 10-year plus of the visa bulletin for EB3 visas. And I'm going to explain a tiny bit the chart and maybe you'll make the proper comments. What you're seeing on the y-axis is the number of days. That the visa, was the current date, the visa for filing according to the bulletin. And obviously, when there are no days, when it's 0 means the bulletin is current. And when there is 365 days, that means a year. When there is 1,200 days, obviously, it's many years that the bulletin is showing that they are behind in visas. Okay? So the reason to show the history is that it's not unusual for the bulletin to have these huge fluctuations suddenly out of the blue and suddenly become current. So it's important that people don't panic, not always panic right away on what happened with the bulletin board. La gráfica que les estoy mostrando es la última década, más de 10 años de las fechas de los boletines desde octubre de 2013 hasta obviamente julio de este año. Como se dan cuenta, obviamente 200 días, 300 días, 1 año, 2 años, 5 años, lo que sea, pero des en cuenta cómo el boletín puede de pronto mostrar que hay una retrogresión grandísima de varios años y de pronto un mes después o un par de meses después se vuelve otra vez actualizado, está completamente actualizado con la llegada de las visas, para que obviamente la gente no se asuste y no les entre pánico, parte de la razón de la discusión de esta noche. So part of tonight's discussion was to tell everybody that we all have to be patient, but there is a reality, and that reality looks like this picture. Bulletin can look horrible, and suddenly looks really great. But that's just the way the process works. How the date suddenly jumped from being totally current to suddenly be 1,200 days behind. I don't know if any one of us has a good explanation for that. The case, for example, in just before COVID, where we were current, suddenly everything went, and suddenly on April 23rd, suddenly went again for 1,200 days, and the very next month, it was cut in less than half. No, not a good explanation on how those things get actually moved. I don't know if you want to add something to that part.
Yeah, I think it's important for everybody to understand that what we're seeing, while it is it's unfortunate that there is a longer wait, that this is not abnormal, and that generally when we see those spikes in time, we oftentimes a few months later, we see significant relief from those longer times. I mean, if you sort of look at, the graph that it shows that even those periods of high retrogression generally are short-lived, and you see significant relief from there. So, sort of just this is not something that is abnormal. It's something that happens periodically. And so sort of just, continue to check the visa bulletin and bear with the process. As soon as is the visa bulletin shows you're current, we'll continue to move your case along as quickly as possible.
And the most important thing, Kevin, maybe to emphasize, get in line. Get in line, because in a
Yes.
matter of a month, your case can become current.
Absolutely.
Yeah.
And the quicker that you can have, for the nurses, the quicker you can have the things ready that you need to get ready. So the quicker you can have transcripts and degrees and copies of things so that you can get your date, the better, because 1 month, if you can file something 1 month and you can get on this side of the visa bulletin, that could, I mean, that could mean, a year faster than someone else, depending on when you file, right? So
Mhm.
it's important to get your date. And if you're a nurse and you're thinking about being in the process, the one thing that you can really control is being ready. Being ready, once you get that job offer, being ready to move forward in the process, getting your date.
Okay. Okay. So, lo importante que les estamos diciendo es, eh, obviamente no es, Kevin les dice, no es inusual tener estos momentos de retrogresión en las visas, de que las visas de pronto por un periodo tienen una demora larga. Normalmente, históricamente, lo que ha pasado es que cuando eso ha sucedido en no un tiempo muy largo, de pronto viene bastante una situación buena por un tiempo largo. Obviamente el gobierno y el Departamento de Estado están tratando en la mayoría de las circunstancias agilizar el proceso. Lo que se está viendo en este momento no es nada fuera de lo inusual, pero si ustedes ven la gráfica, se dan cuenta que hemos pasado históricamente por estas circunstancias y han habido periodos largos donde la situación obviamente ha estado sin ningún problema. ¿Ok? Um, I know that tons and tons of questions are available, but I know a lot of people wants to say, everybody is an immigration lawyer. When it comes to their case and say everybody wants to be an immigration lawyer. Everybody tells you, why not EB2? Why not HB1? Why not O1s? Why not J1s? Why not this? Why not that? Everybody becomes an expert on immigration. Very briefly, because we are way past the time, but do you want to say something about some of the work visas, Kevin?
Sure. So I'll start with the easy one is TNs. So TNs require you to be from Mexico or from Canada. So if you are not a citizen of Mexico or Canada, a TN is not available to you. If you are a citizen of Mexico or Canada, then a TN could be a potential option for a work visa for you to work as a nurse at a hospital. We can get those fairly quickly. But those are only available for those citizens of Mexico and Canada. Um, H-1B visas, oftentimes you hear people say, why not H-1B visas? I think there are a few main reasons. One, some employers are subject to the H-1B lottery. If they're not a nonprofit healthcare system that's affiliated with a university, then they may be subject to the H-1B lottery. And the lottery, their odds of getting you selected are roughly 22%. So they may not be willing to, you may not get selected. Some employers don't want to be in the lottery. If they are a CAP exempt employer, H-1Bs are just for nurses, they are a little bit tricky because the USCIS believes that nurses a nurse, you can become an RN with an associate's degree, and H-1B visas are for those foreign nationals and those positions that require at least a bachelor's degree. And so oftentimes people will say, well, I have a bachelor's degree. Why can't I do an H-1B? And the real question is, does the job itself require a bachelor's degree? And so H-1Bs can be available for nurses that are in sort of specialized positions or at healthcare systems that require bachelor's degrees in order to work there.
And,
So,
and allow me to translate those two parts before we talk a little bit about the EB2s, and maybe we don't necessarily have to go through all the other ones.
sure.
But obviamente las visas TN solamente son aplicables a los ciudadanos mexicanos y a los ciudadanos canadienses a través del Tratado de Canadá, Estados Unidos y México. Estas visas obviamente son deseables solamente particularmente la gente de estos dos países porque facilitan obtener una visa de trabajo bastante rápido y obviamente el resto del proceso se puede hacer mientras que ellos están acá. El problema con la visa H1B, aquellos que no saben que es la visa de trabajo, es que son visas exclusivamente para profesionales. Hay varios problemas. El problema número uno es muchos hospitales no clasifican exentos al requerimiento de la lotería de la visa H1B. Si no eres una institución académica, si no tienes esa afiliación, significa que tienen que entrar a la lotería de la visa. Los chances de que te adjudiquen la visa en la lotería es más o menos el 22%, uno de cada 5 casos. Significa que una visa de H1B se puede demorar fácilmente 3, 4, 5 años, así que no hay ningún incentivo grande para muchos empleadores de seguir la ruta H1B. Por el otro lado, aun si tienen los requerimientos de ser exentos de la lotería, ¿ok? Ellos tienen que demostrar, y esto es un problema al USCIS, que el trabajo, porque los enfermeros registrados en los Estados Unidos, recuerden que hay dos títulos de enfermeros profesionales y uno es el título de asociado, que no se considera un título formalmente universitario, sino un título técnico. El gobierno tiene que, el empleador tiene que demostrarle que la localización donde van a trabajar es exclusiva y requiere exclusivamente enfermeros que solamente tienen el grado universitario. Requiere muchas cuestiones logísticas de si lo van a aceptar, de si hay personas que ya están trabajando, que tenían el otro título, muchas situaciones que muchos empleadores no estarían muy interesados porque los excluye también de poder recibir enfermeros nativos americanos en esas posiciones. Entonces tendrían que hacer una adjudicación particular a ese tipo de visas. Obviamente hay más detalles relacionados con esto, pero esto es uno de los grandes motivos por los cuales no son muy populares en el área de enfermería. Maybe just to, I don't know if you want to say something about the other ones, but I think the EB2 is maybe the only one making a little mention. Kevin,
Sure.
I want to file EB2. Why don't you file EB2 for me? I'm an EB2 eligible. Oh, no, I'll do it myself. All this people think that they are all experts. So EB2s, let's talk a little bit about EB2s. Who qualifies for an EB2 and why can hospitals or why don't hospitals apply for EB2s?
So EB2s there are several different classes of people who would qualify. Um, the first is those positions that require a master's degree, so or higher, an advanced degree. The second is a job that requires a bachelor's degree plus 5 years experience. The third is what they call a national interest waiver, in which it would be in the nation's interest to waive the permanent residence process, the PERM process for someone because they are working on something that is of substantial uh, importance and that has sort of a national reach. Um, And then the last is really those positions that are in which someone is an extraordinary scholar or researcher. So those are the typical classifications of people that will qualify for a EB2. Um, why don't hospitals generally pursue EB2s? It's because most of the positions at which they're trying to fill don't require those things. So if they're hiring an RN for an EB2 position, they're saying either that position requires a master's degree or that position requires a bachelor's degree plus 5 years experience. Now, you may have those qualifications, but what they're saying is that the job itself requires that they would not take someone else that has less qualifications. So, they're saying, well, I wouldn't take someone who has a bachelor's degree plus 3 years experience for this job. And oftentimes that's not the case. Oftentimes they would say, we would love to have a nurse that has a bachelor's degree plus 3 years experience. That's great. We'll take them on the spot. And so oftentimes the jobs themselves don't qualify for EB2.
It requires kind of carving out very specific areas or very specific jobs, which are very hard to do and oftentimes to even justify that those are really the requirements. And that's why hospitals really shy away from those areas. La
Right.
visa EB2 tiene unos requerimientos específicos. Tiene que ser una persona con títulos avanzados, maestrías, etcétera. O si tiene una carrera universitaria más por lo menos 5 años de experiencia. Tiene ciertos requerimientos para que un hospital pueda demostrar que el requerimiento es para una visa EB2. Tiene que mostrar que todas las personas que trabajan en esa situación tienen esos mismos requerimientos. Ellos no pueden decir, esto lo estoy haciendo para traer a una persona, pero el resto de las personas puedo recibirlos. Y esto se vuelve una cuestión complicada porque no es una cuestión de solamente decirlo, significa que toca seccionar partes del hospital donde estos se vuelven los requerimientos específicos de eso. Esto es algo que bajo las situaciones normales no califican, no permiten. Todo esto siempre nos lleva de vuelta a que la ruta más sencilla y la ruta más normal es obviamente ir por el proceso EB3, con la excepción obviamente de las personas particularmente mexicanas y canadienses, donde la ruta de TN siempre está disponible. Esa es una ruta que siempre está disponible. Las visas HB1 en realidad no están. No vamos a discutir la visa O1 y J1 y F1 y L1 por el interés del tiempo, pero en un futuro vamos a charlar un poquito más de eso. Kevin, first of all, I really appreciate you giving us well over 2 hours of your time. There is a million questions here. If I start covering one, means that I have to answer a lot of them, okay? All I will say to a lot of people that I hope that this conversation was helpful. And I know people have a lot of expectations. Maybe just a final word, which is, don't panic. If you are in line, you are in a good place. And things tend to resolve always better than you think. So be patient, take your time, breathe deep. And I think that's the best that we can say. For those who are starting the process, as you said, let's try to finish your requirements, get your paperwork in line. Let's try to get in line as quickly as possible. And in our opinion, that's the best strategy. If you are in line, breathe deep, take your time, and I think we're in a good place. Will you concur with that final statement?
Absolutely. I think, if you're in line, you've done everything that you can do, and now we're just waiting. So just make sure that you remain calm. We will monitor your case and we'll, move forward as quickly as possible. And if you're not in line, do everything you can to be ready for when it's your time to file.
El último comentario que Kevin y yo estamos haciéndole a todos es eh, tranquilos, que el proceso tiende a resolverse mejor y más fácil de lo que la mayoría de ustedes creen. Me da pena no poder contestar los cientos de preguntas que nos llegaron, pero obviamente en el interés del tiempo de más de 2 horas de charlar de esto, yo creo que les resolvimos muchas de las dudas. Quiero que tengan en cuenta de que si usted está haciendo el proceso, lo que más tienes que enfocarte es trata de hacer el proceso formal lo más pronto posible, tener tu documentación y entrar en la línea, entrar en la fila, porque la situación tienden a resolverse más rápido de lo que ustedes quieren, ¿ok? Paciencia, tranquilidad y paciencia, que todo eh, se resuelve para, para todos de una manera buena. Ok. Kevin, uh, you're a gem. Thank you very much. Okay.
Thank you for having me.
I cannot tell you how great I think this conversation has been. I hope that a lot of people have learned a lot of things about the process, and we will continue monitoring. We will invite you soon enough to have more discussions about immigration, and that always. I want to thank you, a million thank yous from us. I think it was a very good conversation. Carrie, do you want to say something else? Muchas gracias a Kevin y muchas gracias por toda su ayuda y toda su colaboración en ayudarnos con esto. Carrie, you want to add something?
Yeah, thank you so much, Kevin. This is really an important topic, and we're so grateful that you came to give your expertise. So we appreciate your time tonight and your knowledge, and look forward to seeing you again sometime soon. And thank you for all the help you give all of these candidates to move their process along.
Yeah, and Miller and
Absolutely. Thank
Johnson
you.
is the #1 firm that we're actually working right now to
Absolutely.
help everyone into the process. So I want you to know that you are in wonderful hands.
Yeah, absolutely.
Okay.
Okay.
Muchas gracias a todos. Les agradecemos mucho haber venido. Espero que esto haya sido. Carrie, do you want to say something about the next seminar just before we close?
You know what? I just don't have it on the tip of my tongue, and forgive me for that.
Okay, not a problem. We'll send the formal.
Yeah, we'll send it out. It's 2 weeks from today, and we'll make sure that everybody gets a notice.
Okay. Muchas gracias a todos. Muchas gracias por haber venido. Acompáñenos en nuestra próxima reunión. Again, good night. Thanks, everyone.
Night, everybody. Thank you.
Everyone.
Thank you very much.